Mr. Speaker, sir, I raise to initiate the discussion on matters of public importance under Rule 50 pertaining to Forest Conservation Act 2023. Why there is an apprehension that this act will affect us is because of the past bitter experiences. I am very happy the House is going to utilize Article 371A to defend our rights, and that a resolution to UCC is going to be passed. And I believe out of this debate and conversation, another resolution to protect our land, our forests will be adopted. Mr. Speaker, sir, as I stated, there are a lot of speakers. I'll be very brief and to the point. Over the past years, Mr. Speaker, sir, as I've stated, the bitter past. In the year 1998, 15th September, the Ministry of Environment and Forests has sent a letter, the applicability of Forest Conservation Act 1980 to the state, along with Home Affairs Ministry Office Memorandum, which was sent to our state again. Another letter from the Department of Legal Affairs, Advice C section. Here, the learned Additional Solicitor General, via his opinion, dated 8/8/98, has opined that the Forest Conservation Act 1980 is applicable to the state of Nagaland. When they pass a bill, knowing fully that Article 371A still protects us, they impose it on us. That's why today, the need for deliberation, discussion on such issues is of paramount importance, and adopt resolutions. Mr. Speaker, sir, the Forest Conservation Bill 2002 introduced by the Union Ministry of Environment, Forest and Climate Change got its clearance from both the Houses of Parliament despite several objections from different corners of the country. Apparently, the government introduced the bill, which is now a law. The Union government made amendments in 2023 to the Principal Forest Conservation Act of 1980 and inserted two ominous fates for Nagaland and the entire Northeast states. The amendment weakened the central forest laws on protection and environment and conferred full powers of use of forest land, irrespective of ownership, to the central government within 100 km radius from LAC or international boundaries for strategic linear projects and national importance and concerning national security. Yes, Mr. Speaker, this bill ensures and protects sustainable forest development in order to meet the economic, environmental, and social needs of the present and future generation. It removes the ambiguity surrounding the definition of the term forest. Now the Act has extended its protection of forest areas irrespective of ownership that are not officially classified and notified as forests in a government record as on October 25th, 1980, but are ecologically sensitive. Interestingly, the amendment included a preamble that seeks to harness the country's rich tradition and preserving forests and biodiversity to tackle the climate change. Mr. Speaker, sir, when you go through this, the above objective seems laudable till one sees the exemption clauses. The Act exempts projects related to economy and security of national importance within 100 km of international borders. Such projects would no longer require forest clearance, as it removed the 1981 Act restricting on creating infrastructures in the reserve forest areas. In other words, under this new amendment, both protected and unclassified forest areas can be encroached in the pretext of aiding national security and creating livelihood opportunities for those living in proximity within the forest, which the forest covers. It is true, Mr. Speaker, that infrastructural and industrial developments are inevitable. However, by allowing such activities as creation of checkposts, fire lines, ecotourism facilities, safaris, silviculture, exploration, dams, 6-week surveys, etc. Instead of preserving our precious forest lands covering, which we are so proud of, they are just made more vulnerable for damage and destruction. As I stated in my opening remarks, our apprehension is not without a basis. It may be noted that the Supreme Court order on February 2019 attempted the eviction of millions of tribals from the forest areas. The Forest Rights Act 2006 to protect the above category of people hardly succeeded in providing security of life and shelter against the capitalist-driven forces. Though it did not affect the Northeast India much, it had already set a tone that forest and wildlife concerns may be politicized for another national and commercial interests. The present act substantiates the fear of the people, especially the stakeholders, the tribal lands in the Northeast, which is surrounded by international borders. Mr. Speaker, sir, it may be noted that Mizoram extended the Forest Act after its Legislative Assembly cleared in 2009 as required under Article 371G of the Constitution, which is provided to Mizoram. The Nagaland Legislative Assembly, with similar requirements under Article 371A, is yet to decide whether it wants the law, although a committee has been looking into it for years. Points to ponder, Mr. Speaker, points to ponder. This act undermines the powers of the state government true and true, since the central government has the full and the last say on everything related to forest. It may be noted that forest is a part of the concurrent list. Prior to the amendment, the state government is required to get a prior approval of the central government to assess forest lands to any entity not owned or controlled by the government. Now, with the present amendment, state government cannot assign any forest area to any entity without the approval of the central government, whereas the central government can take away any portion of land, forest from their projects. These are all subjected to correction, Mr. Speaker. This will definitely make a mockery of Article 71A. It definitely comes in conflict with the constitutional safeguard guaranteed to Nagaland state through Article 71A. Instead of the center seeking the approval of the state to implement any of the bills act in Nagaland, now Nagaland government will have to seek the approval of the central government, which is a very sad story. It has just turned around. The act makes the whole of Nagaland vulnerable since a large stretch of state is covered with greeneries and forests. In general, as has been debated all over the country, this act stands as a threat to tribal lands, a land from which we got our history, culture, and identity. It can either fall into commercial trap anytime or turn into militarized zone in the name of national security. Mr. Speaker, as I stated, Ministry of Home Affairs, Ministry of Environment, Ministry of Law and Justice, they have written in black and white to the state government, stating that Forest Conservation Act 1980 is applicable to the state of Nagaland. So today, if we don't act, Forest Conservation Act 2003 also will be applicable in the same manner. When Mizoram government can take up a resolution in the House rejecting this, why can't we do the same to protect our people in our land? The Union government has tactfully fooled the Nagas into meekly accepting partially Forest Act 2090, which, to be frank, we were arm twisted. The stand taken by the Union government about applicability of Forest Act 1980 in Nagaland was based on a mere opinion of Additional Solicitor General of India. This is very important, Mr. Speaker. It is neither the Supreme Court's observation nor judgment. We have the legal opinion of Y.G. Chandrachud, Chief Justice of India, retired, made on 16/1/1997, who opined that Forest Act 1980 is not applicable in Nagaland under Article 71A. We should explore this one. We should take this copy and go to the court and fight it. Because the Chief Justice retired, he says it's not applicable. whereas a mere additional Solicitor General of India stated that it is applicable, and thereby, basing on his words, three letters has been written to the government of Nagaland. Our rights under Article 71 may be interpreted to become subservient to national security. The written on the wall must be clearly seen, Mr. Speaker, sir. Article 70, which I stated in the morning, which refers to Jammu and Kashmir, was just removed. The Nagaland Legislative Assembly must come out clearly not to accept the Act or the amendment of 2023 thereof. Mr. Speaker, sir, as I stated, the most dangerous, both Article 370 and 371A are both placed in Part 21 of Constitution of India under transactional and special provision only. Article 371A may go the 370 route if we, the present politicians, do not act now. It will be too late, and I'm very sure posterity will blame us. Now, as I stated in the morning, not taking verbal assurances for granted, I think it's high time we also adopt a resolution against this. So while terming this law as anti-tribal and anti-constitutional, I would like to move this August House to pass a resolution rejecting or rather protecting our rights and our land. Thank you, Mr. Speaker.
I will not go into details like the former speaker who has turned this house into an operation theater and thoroughly diagnosed every portion of the hand. All his points are very educated. We thank him for the research that he has conducted. Speaker, sir, I will speak in simple terms as how an average common citizen like me will understand and has understood the entire issue. At the outset, how do we understand the English word conservation? In simple terms, it is for preservation, reservation, it is for regeneration, and it is for protection of our forest land. Now, the Principal Act of 1980 states about conservation of forests and everything connected with conservation. So, we will look it through that window and from that aspect of the act. And we consider what the 2023 latest amendment, it contravenes the very spirit, defies the very intention and the motive behind the enactment of the Principal Act. It is all about deforestation, it's about destruction, de-reservation, anti-preservation, anti-conservation. So it contravenes directly, it conflicts with the entire idea behind the policy. So we are baffled to take in the first place as to how such security-oriented acts can be fitted in through a Forest Conservation Act. I stand to be corrected, but in my simple understanding, it would be more appropriate to have brought this act, this Amendment Act, through the National Security Act. Rather, if it is for anything other than promotion of the forests, activities related with it, construction of highways. It can range from anything to a single lane up to an 8 lane. And you can imagine the size that a 4-lane, 8 lane will consume. And it is for establishment of real estate activities. It is for establishment of strategic plans and things related with the national security. In any case, this amendment, this act, is not in the interest of the forest dwellers, the indigenous people, and the tribals, especially bordering the international, dwelling in the international borders of this country. In the south, southwest, southeast, further up in the northwest, they have a maritime border with the ocean, the seas. It is especially the north and the northeast which borders with our other nations through the forest lands. It will have multiple implications and will be against the very interest of our lives. India, as it is today, let us view it and classify it, categorize it into 3 broad sections. The constitution of this union, as has been stated earlier, is some 500 old princely states. Excuse me. One, by concept, through the Constituent Assembly. Another is through the activation of the instrument of accession. The third is through a political agreement. And we fall in the last category. It is out of a condition which was put forward not to a court, not to an honorable court of this country, but it was to the government of India after they ensured by a constitutional guarantee to the people of Nagaland. So our focus, the attention is on the stand, not of any courts, but the stand of the government of India. So what they do with the other parts of the country, our assembly here, our state and our people cannot control. It is beyond our capacity to influence the policy of the nation. As it is, we have only one member in the upper house, another in the lower house, which is lost in the ocean of voices when we debate any policy of the nation. But our elders, the pioneers, fully knowing that ultimately, one or the other day, we would be facing such kinds of challenges, had asked for it through the 16 points to the government of India. And we are grateful that 2.5 years after 1960, on the 2nd of December 1962, this Article 371A was enacted and given to us to protect our land, our interests, and our people. Our case is something like the Rip Van Winkle, the story that we read in school in the English prose. We were sleeping over it. These powers were vested in this house since the inception. For more than 50 years, we were in deep slumber. Like Rip Van Winkle suddenly woke up and started becoming aware of his surroundings. Today, we have realized our situation. But the protective provisions we have also realized. But we have not activated it for more than 5 years. It is only in the 60th year of the state that we are putting this into action. That too, repeatedly I would say, the credit goes to our leader, Mr. Rio, who took the risk of testing the waters and shaking these clauses and provisions as to what extent thus the government of India still stands in their commitment through a constitutional guarantee. So today, we are confronted with several national acts. But why are we doubting? Why are we scared? It's repeatedly all the speakers have stated that it starts with notwithstanding anything in this constitution. Anything, notwithstanding anything. No act of parliament. Read it properly. Is the Forest Conservation not an act of parliament? Is the Municipal Act not an act of parliament? Will the UCC not be an act of parliament if it is enacted tomorrow? What else it is? So it is all under that category that any act which comes to the constitution of this country will fall under as long as it touches our areas where the land and its resources stands out very clearly. Earlier speakers have stated about certain states in Article 371A. 371 besides A from B onwards. There are many states. But they don't include resources. And in many other states, even land is also not there. This Article 371A is one of a kind. It is exclusive. It is special. It has not been given, nor there is any chance that the government of India will ever give it. So it is up to us to utilize it. 371 today has become like that song, there's a hole in the bucket. We start on any policy, any issue, we talk and we come back again saying 371. So it is for us to realize the powers. We don't have to refer to all the other acts, amendments, provisions and clauses in this particular ministry. Whatever the courts may say, with due respect to the honorable courts, still the interpretation and the stand is of the government of India, where we are focused and should be. So today, I believe the 1980 Principal Act was not adopted by this House, ever. It was only through a government notification that whatever the titles, whatever provisions are there, has been implemented till now. But, as Chief Minister said, to be on the safe side, even in this act, because 371 says the applicability will be based only on a resolution by the Nagaland State Assembly, I too propose that we move a resolution seeking for exemption of the latest Forest Act. Thank you, sir.
I would like to emphasize is for Nagas, Honorable Speaker sir, and for the indigenous people, as already expounded by the former speakers, land and forests are an integral part of our life. It is our culture, it is our asset, it is our inheritance, and most of all, it is our identity. Now, once we lost the land to the government, then what do we have? I keep telling my supporters, my people, that Nagas are very rich people. Why? Because we all are landowners. None of us are beggars, actually. All of us are landowners. Nagas are all landowners. And therefore, we all are very rich people in that sense. Now, what does this amendment envisage? It is talking about 100 kilometers from the international border. 아마 간수업 전에 아세요? 그거에 또 공감도 하나 올라. 다이도 롱와 보스티브로 아세요? 롱와 보스티브에 the ang itu ama kan honorable minister sab ama kan amila saji paiwang tani ko. Daibi ang aseyo. The ang house in Longwa passes through international border. Honorable Speaker sir. Thamali guri thage ang도 India je homai na. Aro phat to Burma de khai. Ama kan naga koi thage. Like that, it passes through his kitchen. We are talking of international border. Don't you think it will affect directly to the villagers? Forget about forest, even village. Osti tak effect koribo, Honorable Speaker sir. Ido karane, this has to be the provision of the 371A is very clear. Ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. That's what we are debating. And therefore, I would strongly suggest that this August House adopt a resolution rejecting even the 1980 Principal Act, the Forest Act, not only the amendment, because we cannot be selective in our rejection. And therefore, I would strongly propound that it has to be, we have to go back to the Principal Act, and this House can decide on that aspect. Thank you very much.
First of all, since the Forest Conservation Act 2023 is an amendment of the Forest Conservation Act of 1980, I think we need to understand the background of the Act first. I'm afraid I may repeat some of the points which some of the members have already mentioned. The Forest Conservation Act 1980 is an important central statute for the conservation of forests in the country. It provides that the preservation of reserve forests, use of forest land for non-forestry purpose, assigning forest land by way of lease or otherwise to private entity, and clearing of naturally grown trees for the purpose of reforestation. All of these require prior permission of the central government, and any loss of forest cover would be required to be compensated by the user agency. This act is applicable throughout the country except Jammu and Kashmir. Because in order to implement this act in Nagaland, the state government issued notification dated 3rd July 1986 that the provision of Forest Conservation Act would be applicable only to government reserve forests and such other forests and wildlife sanctuaries under the control of the state government. For your information, we have only about 2% of the state's total geographical area covered under forest. However, the applicability of this act had its implications following decision of the Honorable Supreme Court. One of the implications of the Forest Conservation Act 1980 was that the provision of the Act initially was to be applied to the notified forest land only. However, subsequent to the judgment dated 12 December 1996, which is popularly known as the Kodavarman judgment, the Act was made applicable to all forest areas, with forests being defined as per the dictionary meaning of the word. The Oxford Dictionary meaning of forest states as a large area covered chiefly with trees and undergrowth, and another meaning of forest states as large number of dense mass of vertical or tangled objects. Cambridge Dictionary states forest as a large area of land covered with trees and plants, usually larger than a wood or the trees and plants themselves. Because this would mean that the area under Chum Fellow or any jungle or greenery shrubs is included under the purview of the Act. This decision brought even many of the private forests under the ambit of Forest Conservation Act. This situation gave rise to many apprehensions that the extension of the Act to private forests infringe upon the special provisions granted to Nagaland under Article 371A of the Constitution of India. This contentious issue was referred by the state to Government of India and eventually to Attorney General of India for clarification. Government of India, conforming to opinion of the AG dated 15 September 1998, confirmed the applicability of the Act to all the states. The Government of India's opinion was referred to Advocate General of Nagaland, who upheld the superiority of Article 371A, but did not categorically state that the Act was not applicable to the state. However, despite this, the Forest Conservation Act was never applied to private forest areas in the state, as the state government never modified the notification dated 3rd July 1986. Speaker, sir, I'm going through this sequence of events following the passing of Forest Conservation Act 1980 for information of the honorable members. Now, coming to the present discussion of the Forest Conservation Amendment Act 2023, the bill amends the Forest Conservation Act 1980 to make it applicable to the certain types of land. These include land notified as forest under the Indian Forest Act 1927 or in government records after the 1980 Act came into effect. The Act will not be applicable for land converted to non-forest use before 12 December 1996. This Act also exempts certain types of land from the purview of the Act. These include roads, railways, railway lines, strategic linear projects concerning national security located within 100 kilometers of distance from the international borders, the line of control, etc. As per the recent amendment, Forest Conservation Act is now applicable only to notified government forests or areas and land which have been recorded as forests in government records on or after October 25, 1980. The above exemption would therefore not be applicable to the state of Nagaland since Forest Conservation Act has been made applicable only to government notified forests and such other forests under the control of the state government. Speaker said, we are now confronted with the application or activation, as our previous speakers have also mentioned about the contentious issue of Article 371A, which requires immediate attention. Although we are exempted from the provision of Forest Conservation Act 2023, and also protected by special provision of the Indian Constitution under Article 371A, we should not put the matter to rest, but we need to critically examine the bill for ramification and also adopt certain measures which can be beneficial to the state. We need to also take into consideration the applicability of the Forest Rights Act 2006, also the applicability of Chumland Act 1970 while adopting a resolution or framing our own act. Several societies, tribal hosts, and organizations have also strongly opposed the recent passage of the Forest Conservation Amendment Act 2023 by the Parliament. These organizations allege that the regressive legislation would infringe upon the constitutional protections guaranteed to Nagaland by Article 371A of the Constitution of India and pose a threat to the rights and heritage of the scheduled tribes. Since any act of the Parliament is not applicable to the state of Nagaland unless it is passed by Nagaland Legislative Assembly as per Article 371A, by default, even Forest Conservation Act 1980 and all its amendments would not be applicable. Hence, we need to listen to the voice of the people and address their apprehensions and in the interest of the public and the state, and for posterity's sake, it may be prudent to pass a resolution opposing the new Forest Conservation Amendment Act 2023. Speaker sir, I would like to also briefly mention about the issue of loss of Kemba Fund, Compensatory Afforestation Fund Management and Planning Authority. The salient feature of Kemba is that any user agency who diverts forest land for non-forestry purpose is responsible for compensating for not only the loss of land, but also the environmental loss associated with it. This compensation, including net present value, NPV, and others are contributed to a Kemba account, which is managed by the authority itself. The Kemba funds are utilized for compensating the loss of forest land and ecosystem service, and each year the national authority decides which states gets how much. However, our state is being deprived of the benefit as we are the only state in the entire country not implementing Forest Conservation Act 1980. For example, from just two ongoing projects alone, namely the 4-lane road from Dimapur to Kohima and Dimapur-Zabza railway line, we may have been deprived of almost about 1,000 crores of Kempa fund because of the FCA, which was not applicable to private lands. Hence, when we enact our own law, we may perhaps make provisions to incorporate loss of net present value, which is the monetary value of environmental services provided for the forest area diverted for non-forestry uses, so that we can avail of the provision of Kempa fund. Because these are the issues that require serious deliberations before the House take decision on the matter. Before I conclude my speech, because as one of the members raised the issue of oil palm in the morning, I would also like to make a small mention, as it also relates to land and its ownership. I would like to mention that oil palm cultivation is carried out on the land that belongs to an individual. It is not carried out in government land or natural forest or by destroying biodiversity reserves as in other countries for which restrictions are being enforced. So it is individuals' choice to cultivate or not to cultivate in their own land. For the information of the House, the target set for cultivation of oil palm in Nagaland by the department is only 15,000 hectares, which is to be taken up in the Chum Fellows of foothill slopes, of which only about an area of 1,500 hectares is so far covered. For information of the House, oil palm is a rain-fed crop, and since we get sufficient rainfall, there is no need for any irrigation to be given in our condition. So there is no much fear about irrigating our field, and also about the oil palm is considered as a water guzzler. Scientists have already made a research, and they have already found out that growing of rice, sugarcane, banana, and other crops, which I would not like to mention all the crops, but they consume more water than oil palm. These research papers are available if there is, if any honorable member wants to know more about this crop. Of course, we have another platform, another forum from where we will discuss in depth. About monocropping, there is also a lot of talk about monocropping. Oil palm is monocrop plant, but intercropping can be taken up during the gestation period and even during the normal growth of its life. So, because of the long distance that is maintained, the spacing that is maintained. I would also like to inform the House that taking up of oil palm provides alternative to chum cultivation, as it provides opportunity for a permanent settled farming system. So this prevents encroachment on forests for new chum. So it is not so much of an alarming situation as many people believe it to be. However, I'm happy that at least there are people who have environmental concern. And as I said earlier, this issue can be discussed in another forum if it is required. I don't know whether this is the right forum to be discussing on oil palm. Anyway, thank you so much for the time given to me, Honorable Speaker.
About the Forest Conservation Amendment Act 2023. And much has been deliberated by one and everybody. Respecting the sentiments of all the leaders of the House who have spoken, I also like to put forward a few points, not to take much time. Many a times, the notion that goes out that BJP is against the tribals or the Nagas, much stands to be corrected. The BJP party is a nationalist political party. Everyone knows that. And the RSS is an ideological organization. We are in the BJP party, not in the RSS organization. If you look at all the conversation and discourse that has happened today, in the presence of our Honorable Chief Minister, the leader of the Nagas today, even with regards to UCC, I was witness under Honorable Chief Minister's leadership with the cabinet, the Honorable Home Minister of this country, Shri Amit Shah ji, stated very clearly, and Honorable CM has reiterated that here. With regards to this Forest Conservation Amendment Act 2023, Honorable Union Minister Bhupendra ji has already said that we will be exempted from it. So it is still not an act, it is going to be. Let me want to remind this August House that the Bharatiya Janata Party leadership has always given recognition to the Nagas and to the tribals of this nation. Atal Bihari Vajpayee, Honorable Prime Minister, late Prime Minister's time, we entered into ceasefire. Then his gift and relation with the Honorable Chief Minister of Nagaland of that time, Shri Nephew ji, gave us a lot of incentives and built us up. Today, at the time of the Honorable Prime Minister Shri Narendra Modi ji, we entered into framework agreement. We entered into a possible settlement to come. On this August House, I would like to remind each one that the Bharatiya Janata Party has always worked for the regional aspirations, and it recognizes the leadership of the Honorable Chief Minister, Shri Nephew Ryo, and recognizes the needs of the Naga people in Nagaland. Article 371A. So many times Article 371A, in my short tenure in this assembly for the second term, I only heard during Honorable Chief Minister's 13 and 14 Legislative Assembly time in the paper also and here. If we talk about the past, that Article 371A, Honorable Minister Uncle Kene has said, we were sleeping. We were sleeping during whose time? We were sleeping during the Congress time. Our Honorable MLA, Achandam ji has said, so much of history he has inside him. Nehru ji and the Premier of Burma came, not given chance to speak to NLC, we turned away and went, and the repercussion came was that not allowed the Nagas to speak. Today, the BJP-led NDA government, under Narendra Modi's leadership, has given full right to allow us to speak and express our needs and protect ourselves. Since Honorable Prime Minister Narendra Modi's time, Article 371A has become alive. Honorable Chief Minister has stated, before civil society's meeting, Home Ministry official called and asked Honorable Chief Minister to come, and his leadership brought all the cabinet there. And before we could say many things, when Honorable CM just started, Amit Shah ji said, "Arey aap log chinta mat karo, aap log exempt ho gaya." So let us believe in the central leadership also, and henceforth let us all work together to protect our people, because this is the end of the hour. Recognizing that the BJP Nagaland, led by my VLP leader Shri Y. Patonji, myself and all the honorable BJP leaders, supports Honorable Chief Ministers and this August House any resolution to exempt according to what is needed for our people this Forest Conservation Amendment Act 2023. Thank you very much.
Nagaland TV, Sop Manulaga Awas. Watch us live on Geo TV and on your television sets as well. For Dimapur viewers, we are on channel number 994 in Global Chapter, and Kohima and Mokokchung viewers, switch to channel number 138 on Hornbill Digital. For all news and updates, follow us on Facebook, Instagram, YouTube, and Twitter.